The advancement in technology, which is now coming dangerously close to us living in a world that we only saw in movies and TV programs. Now, the legal industry has found itself in a very interesting situation, and this is the deep end of the technology growth. What safeguards are in place to protect both individuals and organizations? That's one of the questions that we're going to be asking today. How are technologies such as NFTs, the metaverse, CBDC, and crypto, DeFi changing the landscape? And to join Francis here on the podium, we will be welcoming virtually John Walubengo, who is a lecturer at Multimedia University, Vela Kigwiru, who is a doctoral research fellow at the Technical University of Munich. And to join us on the podium, you could come to the stage, as I mentioned your name, Rosemary Koech Kimwatu, who is the policy manager at Safaricom PLC, and Nelly Jerobon, associate member, Chartered Institute of Arbitrators. So over to you, Francis, the floor is yours.
Thanks so much, Eddie. Good morning, everyone. I hope we all had a good night and ready to begin the session today. So we are going to be having a very interesting discussion today with my panelists. Rosemary, karibu sana. Nelly, welcome. And we've got John and Vela joining us virtually. And so our topic for today is basically going to be covering on regulation and policy in the digital era. Now, when we talk about competition law, it's become standard practice globally for organizations to be regulated within the marketplace, whether it's to do with protecting consumers, whether it's to do with fair pricing, and just creating a fair playing field for all the players, for all the organizations. And today we just want to look a bit more into this discussion because we are now in the COVID era. Most organizations are now adopting digital platforms. And so maybe just to kick it off for us, when we talk about competition law, maybe I'll start with you, Nelly.
Yeah.
Because you're coming from the legal, the legal background. Why do you think competition laws and regulation and policy are important? And maybe you could just touch a bit even on how antitrust laws have been implemented locally.
Yeah. Maybe to begin with, it would be very important to understand what is antitrust, what is competition. And if we look at, as you've just mentioned, they are just generally laws that help industry players to just play fairly in the market space and also to encourage innovation. I know tech people hate regulation, but the good thing about competition law, it's a way of, it's pro-market, it's pro-innovation, it's a way of ensuring that also everyone plays fairly in the market. And if we look at the history, maybe a brief history of where these antitrust laws came from, we look at the 1900s in the US, where we had the Carnegie's, the steel industry, the trains, Vanderbilt, and they came to a point where they became so huge and they were very anti-competitive. They were cutting deals, getting into very crazy agreements, and the government sought to see a way of ensuring that everyone is playing at a fair point in the market. And if we look at the same thing that's happening right now in the innovation space, and especially in the emerging markets, we see the emergence of big tech, and we've had time and again that big tech prevents competition in the market or reduces competition in the market. We see we see the introduction of now the antitrust laws. In Kenya, we have the Competition Act. We've gotten into some various international treaties, for example, the GATT, where generally tariffs and trades are regulated. We have emergence of cross-border practice, and we have various laws that regulate this. And it's interesting if you look at how the nexus between competition law and tech comes in. And because of how much these big tech companies are able to collect data, and I mean, it's not only the big tech companies, we also have local companies, telcos, we have banks, we have mobile lenders, and they're able to collect a lot of data from us, from everyone really, and they're able to monetize this. The only problem comes about where this information is used either to the detriment of the people or to the detriment of, to prevent fair competition in the market. And we've had, currently the conversation is that most of these companies do not want the conversation about data protection to come into the realm of competition. They want these two to be separated, and if we look at the US, the EU, this is happening actually, and especially if you look at mergers and acquisitions, people are not implementing issues on data protection when carrying out mergers or acquisitions, which is sometimes brings about unfair practice, because we see big tech using data to actually progress themselves and to have a fair advantage in the market. So, we've seen companies like Facebook or, Meta, acquiring companies like Instagram and WhatsApp, and they've been able to use this to advance themselves. And now, even as they develop the metaverse, we're just wondering where will this go? How will we be able to regulate this huge marketplace that's going to come about, and who will be liable for, or in case if anything goes wrong, or in case of any improper practice, how will we be able to ensure that this is regulated, because they're definitely the gatekeepers, they'd be the executioners and they're the judges. So it is interesting how we'll be able to see how this conversation goes on. Yeah.
Amazing. Thanks so much, Nelly. And I'm glad that you mentioned, about the big tech companies, globally, and what's been happening. We've been reading about that in the news. But maybe let me turn my attention to Rosemary, because you come from a legal background, a lawyer who's operating in the tech space. And so, COVID hit us March 2020, and we saw a lot of transformation, what we're calling COVID accelerated digital transformation. And because of that, there's a lot of transitions that have happened for most organizations, getting their people to work remotely and adopting new technologies such as cloud. So in the last 18 months, what would you say has been the trend locally with mostly the tech companies, and what has been the trend in terms of being able to introduce regulation and compliance laws? How have those been received?
So thank you very much. I think as we transitioned, it has been an amazing time, because we've seen ourselves being able to do things in particular ways. But in the past 18 months, we're seeing a lot of protection of consumers that's coming up. And not just even in the tech industry, even supply chains. There was a bit of a hit in terms of the supply chain when competition came up. And there's been a lot of regulation to ensure that, customers and everybody else has access to things. But in terms of changes, of course, we're seeing the competition authority, which is the regulator, having a keener eye in terms of market conduct. And the key issue here is, how are consumers being protected? And I think that's a challenge that's not coming not just to tech companies, but to all organizations, in terms of how are you affecting the ecosystem in your operations. Of course, COVID was a good opportunity for some organizations. They're able to, leapfrog and, grow much faster. But the competition regulators have been very careful. But also, we find very interesting conversations coming up in the competition space that we hadn't thought of before. In the EU, they have sustainability in terms of competition. So we're even finding that as opposed to looking at, strict regulation and things like that, we also have more sustainable conversations coming up, like sustainability even in terms of competition. So those are some of the few trends that are coming. But of course, enforcement is high. There's a higher, what can I say? Kiswahili would say kumulikwa sana. Yeah, we've seen that a lot. And not just even in the telco industry, in the telco or even the technology space, in your day-to-day things, like supermarket chains being asked, you need to fix this particular clauses in your contracts because they affect you. So that's how that has been. And we're seeing a regulator who's very, very cautious in how they approach issues. But it's a good thing for consumers. Yeah.
And you've mentioned, the competition authority. and the regulator being very cautious in terms of how they approach, because there needs to be a balance. Because too much, you can overregulate, and then you can stifle innovation, and you can stifle the gains that we have made in the past couple of months. And maybe I'd like to now turn to my online panelists and maybe just ask Vela. Vela Kigwiru, can you hear me? Vela, I think you're on mute. Maybe you could just unmute so we can hear you. Okay, I don't think Vela can hear us. Maybe we can come back to her. So maybe we can just, I'll just come back to you, Rosemary, because you did mention about the regulator being very cautious. And so what are some of the challenges that you're seeing right now with regulators being able to introduce certain kind of laws and policies, and especially when it comes to things like Data Protection Act? We saw this coming in 2019, November, but we've not seen, most organizations putting their things in order for them to be, for their compliance journey to be on track. So what would you say are some of the challenges that are hampering this?
I think one of the key challenges, that not just for SMEs and even for bigger companies, is trying to break down the whole compliance system. In terms of how the law has been crafted, it's amazing. Went through public participation, and that was passed, I think, in 2019, November. Right now, there was a public participation happening for the data protection regulations that had been set up earlier in this year. Those we await to see what the final version will be. But the biggest challenge will be in terms of compliance. Are you going to set up systems that make it easy, even for a small business who today engages in a lot of data through the opportunities that technology is giving? Today you have a shopkeeper who gets to use amazing products that transform their lives, like M-Pesa. And you see, she has data, she has information. It needs to be broken down to the common man. How will they be able to interact? Such that now protections happened at a layered approach. By the time the ecosystem, the grassroots, is aware about data protection laws, then now by the time now, as a big organization, compliance is quite easy.
Yes.
But we have players in the tech system who are the biggest players, and those are our consumers and those are our users. And I think that's where the hardest job is right now, creating that awareness. Yeah.
I like that. I like that you mentioned the issue about awareness, especially from the grassroots level, because my grandma in the village, or my grandfather in the village, how do you break it down for them so I can be able to understand that their information is very valuable and that it needs to be protected, that these are your rights as a data subject. And I'd like to turn my attention to a data protection guru who's with us today, John Walubengo. John, can you hear me? John, you can hear me, but I cannot hear you. I think there seems to be a technical issue. All right, I think we seem to be having an issue with our online guests. But maybe just back to you, Nelly. So she's brought out an important aspect of, taking this from the grassroots level. Is this an issue that we have locally, that we seem to think high level, but we don't think about how do we break this down in the simplest form, and how long will it take us to do that before the common mwananchi can understand, the importance of such regulations?
Yeah, and I think it's very important when you talked about the grassroots. When we look at where in our constitution, where data protection holds, we have, I believe it's Article 36, and it provides that everyone has the right to data privacy. And I think it's also important for everyone we need to get to a point where people believe that we have data sovereignty, and that we believe that we have the ability and we ought to be given that chance. And it's our right to own our data, that we can decide when we want our data to be erased, where we can decide that we want our information to be changed. So it's also, I think it needs to get to a point where the common man needs to be, the kawaida, Wanjiko and Chabet and Kibet, people who we can sensitize people that it's important to understand that your data is very important, data privacy is very important, and especially with the Kenyan Data Protection Act coming into place. Within the next 1 or 2 years, we will have this amount of information, this sensitive information being transferred to everyone, that it's very important that companies ought to respect people's privacy, Companies need to give us the right, give us the power to believe that we own this and it's ours, yeah. Yeah.
So I want to turn this to the audience, but before I do, let me check if our online panelists can hear me now. John, Vera, any luck now? Okay, you can hear me, but I cannot hear you, so we still have an issue. So before I turn it to the panelists for a few questions, maybe Rosemary, I could see you wanted to chime in on what Nelly was saying, so maybe I can give you an opportunity as well.
No, Nelly is actually spot on. Yeah, let's give it to the audience.
Okay, no problem. So let me just ask the audience if there's anyone with a burning question that you would like to, ask our panelists, and we'll have a mic come to you.
And as we go around, I think the question to ask ourselves is, other jurisdictions have protected their organizations if they've grown to a certain level. Are we also going to do the same to create an enabling environment for the growth of, our industry? So looking forward to questions.
Okay. All right, there's a question here from the lady at the front. Please go ahead.
Okay, good morning, ladies and gent. My name is Waithera Kabiru from EABL. I'm a marketer, but very keen about first-party data, particularly around, as marketers, we're thinking about what happens when cookie data is no longer available. That's your anonymous data, which we use for targeting, right? And I like to think about data from a cultural context as well. Because if you think about in the more developed markets, the consumer is more mature about their rights or their expectations on how their data is handled versus here. I'd just like to get your point of view on where we're heading to in terms of companies who are now collecting a lot more first-party data, particularly like not just Safaricom, even the e-commerce platforms, etc., and just positioning that against our culture and what is best for the consumer, because now I don't want to be mass marketed to. I want personalized one-on-one engagements with brands.
All right. We can get another question then we can get the panelists to just respond to your question. Okay. Who wants to go first? Nelly, you could go first.
Okay, I could go first. And it's a very good question. Thank you, Nyokabia. Waithera, yes. If you look at currently how consumer data is being, and especially if you look at the context of the Kenya Data Protection Act, the main point, and I think this is very important to look at, the aspect of consent. I believe as we go forth towards the new era, the aspect of consent will be very important. I still believe marketers are able to still use this data. However, the aspect of consent is very important. So, if we look at how the authorities have been able to monitor and they've been able to allow this sort of dominant companies or companies who are able to collect data processors, data controllers, how they're able to collect this data. The aspect of consent is very important. So going forward, I think this is an aspect that companies need to look at very clearly. Yeah.
I'll chime into this conversation from a very different perspective. How I look at it in terms of Africa, for the longest time, it was considered a dark continent. And the main reason that was that way is because we didn't have the light bulbs that data now provides for our markets. For our markets, for even our consumers, the kind of insights that we're able to get in terms of our values in terms of our value, even our own, even how we do things differently. And that can only be attained and even harnessed more if we make use of the data that is available. I guess we're very lucky because we come from a continent that is not overly data analyzed. We're building our footprint as we move ahead. And I think it's important at this point to make sure that we have adequate regulatory space to allow us to harness these wins. I see you smiling. As a marketer, that's a beautiful thing because, there should be a light bulb that lights in each and every path so that how am I making things better for my customers, and how do we then utilize that data to transform the lives of the people that we serve in various markets, various jurisdictions, but as Africans. So the cultural conversation that we should be having is the cultural data revolution, where we are happy about the data that we have, and of course, conscientious use using data privacy laws, but also allowing us to, give products and create value in ways that we could never imagine. Many times people used to say, this particular market cannot absorb certain billions, because there was a whole lot of darkness in terms of the kind of transactions that happened in those places, the kind of interactions that happened between shopkeepers and their small ecosystem. Can you imagine how much value we can unlock if we make proper use of data to create more light bulbs such that we have a true reflection of what our value is, and that's a cultural conversation we should be having.
Amazing. Yeah, so I like what you said, that we're creating our footprint, as we go along, because it's a new space for us. We've not been here before, so there's a lot of unknowns that we're trying to figure out. So thank you for that. Maybe back to our online panelists. Let's see if we can get them now, because I'd really want to hear from Vela and Walubengo. Hi, Vela, how are you?
I'm fine. Sorry for the tech problems.
No problem. Good, we could finally get you. And I just wanted you to chime into the discussion, because what I really wanted to ask you is the question that I asked Rosemary about, the challenges that you're seeing in the regulatory space. Because I remember one of us here yesterday said, Ali Hussein said that when we're talking about the bill that was trying to regulate the ICT practitioners, you can't regulate, something that's not fully developed yet. I don't know what your view is on that when we talk about regulation and policy in the digital space.
Okay, thank you so much for the opportunity. It's a big topic, but time is limited. So I'll identify some of the problems that are associated with regulating digital markets from a competition law perspective. So one of the problems, considering the characteristics of digital markets, such as network effects and the dynamism in this kind of market, one of the questions that has been pertinent is whether competition policy is an effective tool or an adequate tool to regulate digital markets. And one of the issues that competition agencies have faced is determining the relevant market and also determining the market power, especially in mergers and acquisitions. In this case, for example, most of the digital markets are no prizes, they're free, and therefore using the traditional evaluation mechanism whereby competition agencies will look at the turnover and the assets in order to determine whether the merger should be notifiable or whether a digital platform is dominant in the market and is abusing its dominant in the market is highly applicable in this case. So what most competition agencies are doing is to define market power as data or the ability of digital platforms to hinder entry of other platforms. And another challenge that is facing the digital regulation policy is information or knowledge asymmetry, because most of our practitioners or regulators may not understand the business models of this digital platform, and therefore there's need for agencies to invest in softwares, in data analysis tools in order to be able to counter this kind of market. And another challenge that my colleagues have also addressed is how to strike the balance between regulating competition and not strictly innovation in the market. Sometimes we can overregulate or we can underregulate because this markets not only change, but they can also substitute with each other. And therefore, it's not even clear to have a delineation between what is really being abused and what is not being abused. And taking this back to the African market, every time we talk about digital platforms, we tend to give Facebook, Apple, the big tech companies attention as if nothing is happening on the African continent. And this is some of the things I've overemphasized in my scholarly writing and discussion, is that there's a lot happening on the African market. We have Jumia, and the Competition Authority of Kenya has even been able to analyze a merger between Branch and Sanctuary, which I think Branch is a digital financial platform. And also the South African Competition Commission has initiated a market inquiry into the digital market. So considering the peculiarities of African markets, it's coming a time when we need to first of all do an analysis and market surveillance so that we can understand what are the digital platforms available in the African market, what are the startups, and what are the challenges that are facing. And another big challenge regarding protecting consumers, I think my colleagues have handled this issue, is how to determine consumer harm. In the traditional setup, consumer harm is usually determined in accordance to prices. So the lower the cost, we'll argue that then consumers are benefiting from the regulation of competition. But the fact that most consumers don't have to pay for some of these digital platforms, there's need to evaluate consumer harm differently. And as I've already stated, the alternative is to look at how the exclusionary conduct that the platforms are engaging in, so that hindering other platforms entering the market, and that means consumers are not able to benefit from a competitive market. And as I wind up, there's another problem that in the legal market, COVID-19 has really shown that the legal sector has to make use of legal technology. And in regards to data protection, there's a conflict between data protection and ethical obligations of lawyers in ensuring confidentiality of the information that their clients give them. So in this case, I think our Bengo will touch on this as an expert in data protection. Lawyers have to be cautious of the ability of hackers hacking the software they're using in storing data from clients. And finally, as I finish up, the question of jurisdiction, because most of the digital platforms are established outside Africa, and the issue of collecting data, which sometimes it has to happen through foreign channels, such as diplomatic missions. So this is some of the challenges that our competition authorities and our regulators are facing, but we should be heading somewhere. Thank you so much for this.
Thank you. Thank you so much, Vela. And I like something that you've touched on, the fact that one of the challenges that the regulators may not be able to understand the business model of, the technology platform or the digital platform. And so with the last 5 minutes that we have, maybe, Walu, can you hear me?
Yes, I can. Can you hear me?
Great to have you, Walu, and welcome to this discussion. Maybe you could touch a bit on the issue of, crypto and blockchain, because there's been a lot of fuss and discussion about it lately, with a lot of governments wanting to go that direction. A lot of there's a trend globally that we are seeing. What direction do you see regulation taking when it comes to such technologies?
Okay, probably I'll touch on that and then jump into the data privacy aspect immediately after that. I was privileged to serve on the blockchain and AI task force, and we actually recommended that government should consider having digital assets. I mean, If you look at the Ministry of Lands, where there's a lot of, should I say, corruption, where you have one title deed being owned by maybe 2 or 3 people. This is really a use case that blockchain can solve. If you tokenize the title deed and put it on a blockchain, then it becomes much harder for people to forge or change things so that 2 owners end up claiming ownership to a single title. So blockchain is really a special database that can bring transparency and accountability in the way we keep records. And from the blockchain task force, this was our selling point, to improve government records in the public sector. But of course, on the other side, there's the fintech aspect, where there's a lot of hype, or should I say excitement, around cryptocurrency, which is a reality. I, for example, also have some cryptos. I have some fractions of Bitcoin, among others. But then you find that the central bank has a very sort of careful position about how these cryptocurrencies, actually they have a straight circular to banks that they should not entertain cryptocurrency, or if they do, they're doing it at their own risk. But we're saying there is an opportunity, even for central bank itself, to introduce blockchain in the operations, not necessarily from the crypto side. They could actually own the crypto by creating the legal tender in a tokenized manner. So I think World Bank and IMF are calling it central bank digital currency. Basically have your own crypto with the intention of ensuring that there is transparency and accountability within the banking sector. If you allow me, I could want to jump now into the data privacy side.
Sure, you can go ahead, but you can do it in like 2 minutes so we can wrap up.
Okay, yes. So the data privacy conversation is also quite important, and it's not really gaining traction as it should. Of course, in the private sector, there's more attention to it than in the public sector, because private companies are obviously scared of penalties that they may incur in case they violate the act. But the quickest way to promote privacy is to make sure Wanjiku is aware of her data rights. And basically those rights include, among others, the right to consent. Before you collect my data, I need to consent to that. The right to access, I need to access data you have about me. If you recall the Huduma number issue, government has collected a lot of data about its citizens, but there is no clear way of how Wanjiku can then access that data to confirm what is this thing that government has collected about me. Is it really the correct position, and how do I go about accessing my data? There's a right to be forgotten. If you left a company maybe 5 years ago, why should we still keep your data, unless of course there are other legal requirements for them to do that? The right to transparency. Who else is that company sharing my data with? It's one thing to collect the data, but most companies will not bother to tell their customers that in the back end, they're actually sharing for monetary gain that personal data with third parties. It's not wrong to share. What the issue is that you must inform your customers that you're indeed sharing that information, and perhaps seek their secondary consent. There's the right to data minimization. If I'm subscribing for M-Pesa, you have no reason to collect data about, I don't know how many plots of land I have in Kitengela, because that has nothing to do with my need to have financial services on my mobile phone. So the data controllers must re-examine the data set that they're collecting and ensure that they're fit for purpose. And finally, Wanjiku should be aware that they have a right to complain to the data commissioner. We now have a data commissioner, but unless people are aware that they have this right, and if violated, they can launch a complaint, then the data privacy conversation will never take off. Just to conclude, I think one in the audience was asking about marketing data, the so-called cookies and whatnot. That is also very important. If I visit your website and you're collecting data about me, you are obliged to tell me that indeed you're collecting that data. The data that tells you which page I clicked on, how long I stayed on the page, so that you can use that to later on send me some marketing stuff. The law doesn't stop you from doing that. The law simply tells you that you should tell Wanjiku that that is what you're doing and give an opportunity to say it's fine or not, the so-called cookie policy. Thank you. Back to you.
All right. Thank you so much, Walu. Very interesting, issues that you brought about there. There's the issue of the data, the rights of the data subject, and there's the issue of the consent mechanism for you to use as a data processor or controller when you're collecting information. So thank you so much, my panelists. Thank you so much, Rosemary. Thank you, Nelly. Thank you, Vela, and thank you, John Walubengo. You've been amazing panelists, and I think it's been a great discussion on competition law, regulatory, and policy. Unfortunately, we do not have any time for more questions, but we really thank you for engaging with us on this. And I'd like to hand it back over to our MC,